Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton shared this article that's on your screen right now from CoinGate titled, "Has XRP Already Won the Long-Fought Lawsuit Against the SEC?" And he shared some thoughts on this topic, and I'll tell you right here at the outset of the video. He ends up saying ultimately, there is no guarantee that Ripple's going to win this thing. It's not all sewed up at this point. Now, that doesn't mean, as you'll see, it doesn't mean that he thinks that Ripple is on the losing side. It doesn't mean that he thinks that Ripple has terrible arguments or anything of the sort. But he plotted out for in an easy to understand way why there are more hurdles to get over, and he shared what we should be concerned about. And I don't say that to scare anybody, but let's be informed here. We're the XRP community. It's good to have knowledge, right? And so he shares the things that potentially, like I guess I think it's reasonable to characterize. He didn't say it quite like this, but could potentially be the most alarming. The things where perhaps the judge might look at this whole thing and not side with Ripple. And so he does run through these scenarios. And these are his latest thoughts on the topic. And I think part of the reason that he was going through this is because it seems like, and you can just kind of tell, like if you're in social media, you can tell. The attitude is that this thing's over, Ripple's going to win, that's it. And perhaps that's even why we've seen the price of XRP moving to the upside. And I appreciate what Attorney John Deaton is doing here because he's being a realist. Now, he's still obviously pro XRP, period. And again, like I said, he's not saying that Ripple is going to lose this, but there's no guarantee, and there are reasons that we should be concerned. So I'm going to share with you everything that he had to say. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, I don't want to read this whole article from CoinGate. It's fine, but I did want to highlight a quote. They quoted Ben Armstrong, who of course runs the very popular YouTube channel BitBoy Crypto, which I believe is the largest cryptocurrency channel on YouTube from the United States. Absolutely gigantic. I think he's somewhere in the neighborhood of like 1.5 million subscribers, somewhere thereabout anyway. And here's what Ben Armstrong had to say on this topic. He wrote, "For all intents and purposes, the Ripple SEC case is over. XRP is not a security. Once the formality of making this official happens, it's going to make it very difficult for the SEC to accuse any coin of being a security. This is going to be huge for crypto." End quote. So look, I'll say from my personal perspective, like even after reading John's stuff, like I've admitted the whole time, I don't know what's going to happen, but I'm optimistic for a number of reasons. And I think justice is going to ultimately be done. So I'm still in the camp of I think that ultimately Ripple's going to win it. I'm just not going to say it with quite the gusto that Ben Armstrong is sharing right here. I'm not 100% confident, but I am highly confident. I'll say that I'm highly confident. And as far as this idea of the SEC not being able to accuse any coin of being a security after this, maybe ultimately true, but in the short term, I actually would respectfully disagree. I think in the short term, you're going to see an appeal if Ripple wins, if the thing's fully adjudicated, if there's no settlement. You're going to see the SEC appeal, and they're going to stick to their same strategy in the short term. But if this goes to a higher court and then Ripple continues to win, and maybe it even makes it to the Supreme Court, oh God, I hope we don't go that far, because that'll take so many years. If that happens, then I'm on board. I'm like, yeah, good luck SEC, because you just lost like just about all of the authority that you were pretending to have, officially. That'd be so precedent setting at that point. Here's what Attorney John Deaton had to say about this, though. So check this out. His thread on Twitter reads as follows. Oh, and also I want to give a shout out and credit to Mac Attack XRP, because he shared that CoinGate article first, and then John Deaton actually retweeted that from Mac Attack XRP. Anyway, Attorney Deaton says the following. "Will the judge agree with Ripple? No one discredits the SEC and its arguments more than me. But if people think it's a foregone conclusion that Judge Torres is going to wholeheartedly adopt the argument articulated in Ripple's summary judgment motion, you are likely overconfident. You have to remember, there are two separate summary judgment motions. You also have to remember that the Rule 56.1 undisputed facts and the testimony and evidence gathered during discovery has yet to be unsealed. Therefore, a complete legal analysis is impossible at the moment." So I'll just pause and note, that's obviously true. In terms of the way that they were articulating things. We got that stuff in motions for summary judgment, so we got that. We can see the approach that they're taking. That's not a question mark, but this other stuff is. Absolutely. So you can't do a full legal analysis. And that's why, to some degree, perhaps, and I like the enthusiasm. The enthusiasm's been fun. And we're confident. I think it's reasonably confident, but perhaps might be a little bit too confident, as Attorney Deaton's saying here. Anyway, Attorney Deaton continues. But focusing only on Ripple's motion, I see many people saying the judge will definitely agree with Ripple. Claiming that the SEC can't prove XRP is a security is very different than saying the judge will completely agree with Ripple's arguments for summary judgment. And I'll just pause and note, see, you may recall, and I think this is probably the reason that he brought it up, there's been a lot of discussion on this. I've talked about it on my channel too. And I had a conversation on Twitter, I made a whole video about that, where there was me and Attorney Bill, there was Attorney Deaton and Attorney Hogan, because I had some questions, I was getting to the bottom of some stuff. And so Attorney Hogan had brought up the point, and he's right on this, the SEC is not literally claiming that XRP itself is a security, but that doesn't mean that this thing can't fly off the rails. And so anyway, Attorney Deaton continues, and he says, wait, did I lose my spot? Oh yeah, here we go. One of my first comments about Ripple's motion was it was written for the Second Circuit or above. Ripple is claiming before you apply the Howey test, there must be an underlying contract between the buyer and seller. Let's review the precise language used in Howey. And so pay attention here. And this is the part where you might start to feel a little bit concerned, but just listen to this whole video if you've got the time, because this part might make you feel a little bit concerned right here. And then John Deaton breaks down why perhaps, frankly, the SEC might have a winning argument when it comes to this. I said might have a winning argument when it comes to whether or not Ripple's argument saying that there's no investment contract here, so you lose. He articulates why ultimately that might not be a winning argument. So here's the quote. John Deaton shared, it's on your screen. This quote came directly from Howey itself in 1946. Here's the quote from 1946. An investment contract for purposes of the Securities Act means a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. End quote. So now let's go a little bit further. Let's break this down. Then John says, thus, the SEC will argue the plain language of Howey. They will cite to cases that applied this plain language. The SEC will argue the law does not require an underlying contract. So listen up here. This is the really important part. The plain language reads, an investment contract is, quote, a contract, transaction, or scheme, end quote. Emphasis on or. So pause. You can probably already figure out where the problem is here, right? That this is what Attorney John Deaton is pointing out. Ripple is pointing out that Howey argues that there must be a contract. In order for there to be an investment contract, there must be an actual contract. If you look at the plain language, and this is what we're speculating the SEC is ultimately going to argue, it could be a contract, transaction, or scheme. The or part. So what if it's just a scheme and there's no contract? What about that? So you can see where the problem's coming in, right? And this is why Attorney John Deaton is bringing this up. And now Howey also says, quote, and it's also on your screen right here where I'm moving my mouse. This is, again, from 1946. Howey also says, quote, an investment contract thus came to mean a contract or scheme for the placing of capital or laying out of money in a way intended to secure income or profit from its employment, end quote. And then Attorney Deaton continues and says, in short, since Howey, some cases focus on the or part of the test, a contract or scheme. The SEC will focus on proving a scheme, including XRP's creation, all of Ripple's efforts creating value for XRP, including creating a secondary market for XRP, all part of a scheme. So pause again. Hopefully it's really crystal clear at this point. They're likely, from Attorney Deaton's perspective, he's speculating that it's likely what they'll argue is that all of that all that stuff that's cited, everything Ripple did having to do with XRP and creating all these markets, part of a scheme, and not arguing a contract, because from their perspective, they'll probably just say, we don't have to say it's a contract. It's a scheme. That's problematic, perhaps, right? Attorney Deaton continues. I'm only telling you what the SEC is likely to claim. It doesn't mean I agree with it or that it will be successful. Sometimes when I articulate the SEC's argument, some people misinterpret it. But in order for the judge to agree with Ripple's argument, she will have to agree that her well-respected colleague, Judge Castell, was wrong in Telegram because Judge Castell, in his decision, in part, focused on a scheme, even though ironically Telegram involved actual contracts. That is kind of funny. Think about that. Involved actual contracts, and John Deaton's pointing out Judge Castell focused on a scheme. So, if see what she's saying? He's saying here, if Judge Torres in the Ripple case comes to a different conclusion, that's directly against what Judge Castell said. So if she instead says, yeah, no, it's not about the scheme, there's no contract, you're right, Ripple. That's in direct conflict with precedent, even if not binding, the precedent set by that particular case with Judge Castell. So you can see the problems adding up a little bit here, right? And again, this is not to scare people. I'm not saying it's a doomsday thing. I'm just saying let's be aware of all this stuff, which is why I appreciate John Deaton taking the time out of his busy life to share this stuff so that we know, we can understand the various dynamics. There are a lot of moving parts to all this. And Attorney Deaton continues. This is why I said Ripple's motion was written like an appellate brief to the Second Circuit or the Supreme Court. Ripple's motion focuses, as it should, on the Second Circuit because all of the Second Circuit cases since Howey involved actual contracts, according to Ripple's brief. So pause and think about this. I think what he's getting at here is that regardless of the outcome, whether Ripple, generally speaking, wins or loses, because look, whoever loses is going to appeal, so then it presumably ends up in the Second Circuit. So they're saying upon appeal, and this is Ripple's strategy, presumably anyway, that whether Ripple wins or loses, it's going to go to the Second Circuit, and in the Second Circuit, there are no other cases out there, according to Ripple anyway, that show that there was any sort of instance where a scheme was sufficient, meaning that there was a contract in all the cases for the Second Circuit. So that's why Ripple set this up, because they're counting on appeal. Whether it's their appeal or the SEC appealing, they're counting on it. And they think that argument's going to win in the Second Circuit. That's my speculation anyway. That's what I'm supposing is going to happen based on what I see from Attorney Deaton here. And then John says, it may be a tough sale to get Judge Torres to agree 100% on the underlying contract requirement, and that scheme only applies after you find a contract. I do think the motion is a winner with the Supreme Court and maybe the second. It's possible Judge Torres agrees with Ripple. Judge Torres could disagree with Ripple's argument, but still find for Ripple. She could reject the underlying contract theory, but apply Howey and say Ripple wins summary judgment because the SEC cannot meet the common enterprise prong of Howey. The opposition briefs will say a lot. So there's a lot of ways that this could go down. So again, even to be clear, as he wrapped this up, that was the end of his thread. Even if the judge does not find Ripple's argument compelling in terms of, okay, there's no contract, but there's a scheme there, she could agree with that. But then once you're past that part, that's the part where you apply Howey. She could still then apply Howey and say, this doesn't pass the Howey test, meaning X or B not a security effect, right? So there's a lot of ways this could go. It doesn't mean it's necessarily going to be a slam dunk, but I see very clearly, especially after John Deaton shared this information, why he's stating quite flatly, this is not an absolute guarantee. Doesn't mean he doesn't think that Ripple shouldn't win. It doesn't mean anything like that. And same for me. I think Ripple should win, but there is no guarantee. Now, I'm still optimistic. And in fact, I'll still say right now, I think what's most likely at this point is that there's going to be a settlement. And the reason that I say that is because I think that Judge Torres is going to demand that the SEC must hand over the Bill Hinman, Ethereum free pass emails and drafts of the speech from June leading up to June 2018. I still think that's going to happen, and I think that the SEC will not want to hand that over. That'll bring them back to the table for settlement. It's just a for fun guess. There's a lot of ways this could shake out. Maybe it is fully adjudicated. So this isn't some sort of disaster situation, but you can see that there is cause for some concern, and that's just being honest. That's being a realist. But that's okay. I'm still optimistic that justice ultimately will be done. So that's it. Let me know what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.